Gurmai Ogut, Cahirloch, and welcome to the House, Minister. I support this bill. It includes necessary procedural amendments to ensure the Workplace Relations Commission Adjudication Service will continue in its role to protect the rights of employees and employers. I commend the Minister for his swiftness in dealing with this matter and the cross-party support it has garnered. It amends the Workplace Relations Act 2015 and the Unfair Dismissals Act 1977 in response to the judgment of the Supreme Court. We have extensive employment and equality rights, and it's essential that the Workplace Relations Commission functions in line with the Constitution and that their work is not compromised. On the 6th of April 2021, the landmark Supreme Court judgment in Zalewski versus Adjudication Officer and the Workplace Relations Commission upheld the constitutional validity of the WRC and that the process was a constitutional administration of justice in the state within the meaning of Article 37 of the Constitution, but declared that certain aspects of the procedures under the 2015 Workplace Relations Act were incompatible with the Constitution. So while the WRC was ruled as constitutionally valid, certain aspects of its procedures were not, and so you are rectifying that. The implications of that decision mean the holding of all hearings in private, as provided under Section 41(13) is not an acceptable feature of the administration of justice, and that hearings must now be held in public except in certain circumstances. And up until this decision was taken, all hearings were in private and there was no sworn evidence and names were usually anonymised. It is hard to say that. Anonymised. And secondly, that the absence of the provision for the administration of an oath or any possibility of punishment for giving untruthful evidence is also inconsistent with the Constitution. The adjudication officer should be able to require that certain evidence must be given on oath. These amendments seek to bring the WRC in line with the administration of justice permissible under the Constitution. So proceedings were much less formal than they will be now, and while the pros and cons of that have been discussed to a certain degree, and I'm sure will be more today, overall I believe the change is very positive and that the integrity of the judicial process is the most important factor. Corporate reputations will be sensitive to having their dirty laundry aired in public and open to scrutiny by media. Employees too will be wary of their professional reputations. It might set a standard for cases that go to the level of adjudication. We might see an increase in mediation, which could be positive, although both parties have to agree to mediation, and some of the articles I've read said that resources will have to be monitored by the WRC in that regard. There will always be employees that are wary about escalating workplace relations cases, and I've seen myself how they don't want publicity or attention, they don't want compensation, they just want issues to be resolved. And so we'll always have to make sure that we have space for them, that we respond to their needs. So overall, and in relation to oaths, I think that can only bring more integrity to the process. So again, I think that is a positive move. So in general, we need to bring the work of the WRC in line with the Constitution as part of the judicial process. I support this bill, and I also look forward to the views of my colleagues. Thank you, Minister.